We're now going to move on into areas that are relatively novel in family law, and these areas that have been touched on by previous speakers in other ways. But now we're going to hear more directly about some of the rights, obligations, and problems faced by unmarried couples. First, to talk about cohabitees is Professor Winifred Holland, and I'm pleased to turn the microphone over to her now. Professor Holland.
I'm going to be dealing with the question of heterosexual cohabitation, and my co-panelist Bruce Ryder is going to be dealing with same-sex couples. That's how we've divided up the topic. Now, I just give a summary of my paper at the beginning. It addresses a number of different issues. The first thing is the increasing recognition of cohabitation over the past 20 to 30 years. Secondly, I deal with some differences and distinctions that still exist between cohabitation and marriage. The third thing is I look at some arguments for further extension of rights to cover cohabitees. There's a large portion, the next portion of the paper is on the Charter, and I know that still strikes some terror in the hearts of family lawyers, less so in the hearts of criminal lawyers who are quite used to dealing with Charter issues. And finally, and I think this is quite prescient, I call for some further legislative reforms. I want to point out that at the time of writing the paper, the Ontario Law Reform Commission proposals for change in cohabitation were not then available, so they're not referred to in the paper, but they will be in the final version, which comes out in the published volume. We don't at the moment, of course, have full details of the Ontario Law Reform Commission proposals. We have an outline, so I'm going to just deal with that particular outline. First of all, to deal with changes. 20 to 30 years ago, cohabitees were what I would describe as an invisible group. They weren't recognized at all by the legal system. And when in fact they were recognized, judges would usually refer to them in somewhat derogatory terms. And I've given an example of that, the quote from the case of Gammons and Aitken on page 1 of the paper, where the judge speaks of cohabitees masquerading as husband and wife, so on, which seems rather dated now. Given the way in which cohabitees were dealt with back then, it's hardly surprising that quite a few of them, and I was one of that number, since I was a cohabitee back in the 60s, we decided we'd change our names. So we did actually masquerade as husband and wife by changing names and assuming the name of our partners. And that, of course, is not something that happens these days. Actually, it led me into considerable problems, because after I changed my name, I then went to live in Barbados for the year. My partner and I decided we would marry, and we went along in order to get married. They said, well, you're living at the same address and you have the same name, you must be married already. And consequently, we have no jurisdiction to marry you. So you will now have to supply us with information and have evidence presented that you're in fact not married. So I had to establish that I was not married in order to get married, which seems rather strange. Anyway, before looking at the increasing recognition of cohabitation, I think it's important to recognize that this increasing recognition is part of an historical process which has been going on certainly for hundreds, perhaps even thousands of years. This is not a new phenomenon. I think what we can recognize is the relationship between the legal and social definitions of marriage is constantly changing. It's in a state of flux. And the answers to questions such as what is marriage or what is a family will vary in different cultures and even within similar cultures across time. Looking at the issue over a very narrow time span has led to questions, I think, about the death of the family. And I think all that's really happening is the waning of the so-called traditional family and its transformation into other family forms. That's what's happening. It's not the death of the family as such, it's just a change that's taking place. Now, if we look at changes over the past 20 to 30 years, I think just to look at some of those, there's been obviously a recognition through support obligations first of all, in the Family Law Reform Act. That was from 1978 onwards. There's, of course, recognition through the use of contracts. That also came in 1978. Property disputes. There's been increasing use of unjust enrichment principles. There's also general statutory changes, including in Ontario, the Statute Law Amendment Act in 1986, which extended, changed definitions to include cohabitations in many, many areas. There's been changes to the Canada Pension Plan. The recent amendments to the Income Tax Act were discussed by Mayor Lou Bonotto in last session. And last but not least, there's a lot of changes in employment benefits and so on. So I think there's been very widespread recognition of the rights of heterosexual cohabitees. However, there are some remaining differences and distinctions. The first one I want to deal with is the issue of property rights, unjust enrichment, and so forth. If you look at my paper, you'll see that actually at this portion of it, it covers very similar ground to that covered by Professor Youdan this morning, where he discusses the use of resulting, I don't deal with resulting trust, but constructive trust, unjust enrichment principles, a discussion of the recent Supreme Court of Canada decision in Peter against Beverley. I'm not going to cover a lot of that ground because he's already done that already this morning. I'll just highlight a few of the issues. Certainly the Supreme Court in a series of important decisions in Petkus and Becker, Sorokin, and Peter and Beverley have developed the tests for unjust enrichment. We all know the three-part test of enrichment, deprivation, and absence of a juristic reason for the enrichment. I just want to highlight some of the remaining problem areas. One of them is the types of contribution which are going to give rise to unjust enrichment. I think to some extent, Peter and Beverley, well, to a great extent, Peter and Beverley clears up some of the problems around what were described as domestic contributions, domestic services. These are certainly now recognized as giving rise to an unjust enrichment claim, and the idea that they were thought of as gifts or somehow as non-compensable, I think has now been quite rightly rejected. So at least that part is being emphasized. That in conjunction, of course, with the recent decision in Morden, which I suppose is how we're supposed to pronounce it. Certainly, both of them together provide strong support for recognition of domestic services. I hate that word, but that's the thing. Another issue is the benefits received during the relationship. Is it supposed to be some set-off because benefits were received during the relationship? Those of you who read the BC Court of Appeal decision in Peter and Beverley will remember that that was the reason for saying there was no detriment because the person had already been adequately recompensed by benefits received during the relationship. This is an issue I think that still remains to be clarified and really wasn't dealt with very fully at Supreme Court of Canada level. Another problem is the type of remedy that's appropriate, an issue that Professor Youdan went into in quite a lot of detail. When should we have a personal or when a proprietary remedy through the use of constructive trust? And Madam Justice McLachlin in Peter and Beverley indicated that a personal remedy is to be preferred, and only where a personal remedy is inadequate and there's a direct link between the contribution and the property in question, would a proprietary remedy be appropriate? I think there's still some problems with this whole question of nexus or link. I just saw a recent BC decision, Hartland and Reschke, which is in volume 47 of the RFLs, where even if the person made a direct contribution to the property, they didn't find a nexus. There are other cases where it's difficult to see what the link was. And indeed, from the discussion that we heard this morning, when Madam Justice McLachlin comes to apply her test of nexus to the assets in question, we get into this whole issue of a pool of family assets, and it all gets rather diffuse. So I think there's some problems around that. Last but not least, there are quantification problems. I think whatever remedy one has, there's this whole problem of how to quantify the remedy. And of course, the Supreme Court in Peter and Beverley got into issues of value received and value surviving and created some problems around that, which were also discussed this morning. I think that there's a lot of remaining problems, and these could be cleared up, I think, but it's taken a long time to get where we're at right now. I think the fact of the matter is that Part 1 of the Family Law Act does not apply to cohabitees, and we have to ask ourselves the question, well, why doesn't it? Even with use of unjust enrichment principles, cohabitees are certainly not as well off as their married counterparts. Married spouses under the Family Law Act, you know that contributions are assumed from the fact of marriage itself, and in fact it's possible to access a much greater range of assets in any event. So there's certainly considerable disadvantage from having to utilize unjust enrichment principles as opposed to being subsumed under the Family Law Act itself. There are other disadvantages suffered by cohabitees outside the issue of property principles. There's also the fact that they do not have occupational rights in the family home under Part 2 of the Family Law Act. There have been attempts to argue under Part 3 of the Act via support obligations that there is a possible occupational right, but that hasn't been successful. In England, they used what was called the implied contractual license, which is a very odd kind of situation. I don't intend to go into it in detail. I think it's very much of a fiction and hasn't really been tried in Canada. I suppose if one were desperate, one could use the contractual license. But at the moment, they're certainly not included. Cohabitees are outside Part 2 of the Act, and that's something I want to address. Well, I think intestacy provisions, that's another situation. Cohabitees are not included within the intestacy provisions in the Succession Law Reform Act. That's another example. And the question I'm asking in the paper is whether the time has come to bridge the remaining gap between marriage and cohabitation. Some of the arguments against doing so, I think, can be dismissed fairly quickly. There's this idea that cohabitees are living in sin. I think this kind of moralistic tone to things is something we don't hear very much these days anyway. And I don't intend to spend a lot of time on it. There's also an argument that we should maintain a distinction between marriage and cohabitees. And it seems as though almost that's what one is trying to do, just artificially maintain a gap. And I'm saying, well, why is it necessary? What's to be gained from keeping that distinction in place? If we do extend the rights under Part 1 of the Act and Part 2 to cover cohabitees, I don't see any downside for married spouses. It's not as though there's only a limited pot or something available and one has to suffer if you increase the rights of another. I don't think that's really an issue. The main argument that's used against extension of rights is that the personal autonomy is actually one of the key arguments advanced as a reason for maintaining the distinction. It's argued that there must be freedom of choice in personal relationships and that choices which are made should be respected by the state. I think the question is, how many couples do consciously avoid matrimony? I think there's considerable evidence to the contrary that couples actually drift into long-term relationships without very much thought about the nature of the relationship. In other situations, people start off not being able to marry, perhaps because the divorce from another spouse hasn't come through, and then just through inertia, they just continue to live together and don't bother to go through a ceremony. I don't think one can deduce very much from the fact that they haven't gone through a ceremony and say it's a conscious avoidance of matrimony. I think even if the couple start off as free spirits with the idea of autonomy at the outset of the relationship, there are very considerable changes over time. Children are born, and there's an increasing number of sacrifices made by both partners, increasing interdependence, and I think, I say, whatever the initial intention, it often changes over time. You only have to look at the situation in Sorokin with 42 years of cohabitation and 6 children and very extensive contributions to see how things can change over time. I would like to see us instead focusing on family relationships rather than formal marriage. I think it's possible to acknowledge diversity in these different relationships. The question is the Family Law Act flexible enough to accommodate different families? I don't think the question is whether, when we're looking at marriage and cohabitation, it's a question of, does it look like a duck? Does it walk like a duck? Does it talk like a duck? Therefore, it is a duck, so we treat them the same way. I think that's one way of seeing marriage and cohabitation. I think it's much more fruitful to ask, what is the essence of the remedies in Part 1 and 2 of the Act? And can we include not only ducks and swans and geese and a whole bunch of other creatures, if you'll pardon the sort of Aesop's fable or whatever. I see that in terms of, rather than just saying in marriage and cohabitation the same, whether in fact the sort of remedies that we have can be extended to other family forms. But I do think there are a group of cohabitees definitely who do want to stay outside of a number of obligations, and the contract option must always remain available to people in that situation to actually contract out of the legislation. However, if I were going to live with somebody, give up my job and have several children, I want that down on paper. I want it to be recognized in the contract that at the end of all of this, I'm going to walk away with nothing. And if that's the person's expectation that we're not going to have any obligations, I'd like to have that down in the contract. So I'd put the obligation on people who want to avoid obligations to do so in a contract. Well, what lies ahead? I'm going to just skip very quickly through some of this material because I know we are getting short of time. In the paper, I explore two different things. I talk about also charter challenges to the whole distinction between marriage and cohabitation. There's some decisions going through right now, so this is already going through the system. There's several decisions right at the Supreme Court of Canada level on this question. But obviously, that's one route to proceed. The other thing that's going on simultaneously is a possibility, which I think is the preferable route, of legislative reform. As far as the Charter is concerned, I think the Charter is acquiring an increasing significance in family law, in spite of some of the sort of somewhat ambiguous statements in the recent incomprehensible Supreme Court of Canada decision in Young and Young, dealing with custody. As far as cohabitation is concerned, I think the focus here is on Section 15.1 of the Charter, and I've actually set out the provision in its entirety on page 19 of the paper. Section 15 is set out there. I've also summarized the new test on Section 15, which emerges from the Andrews and Law Society of British Columbia case, which Helena Orton has already dealt with when she was talking yesterday about the leaf intervention in Moja. So she already dealt with Section 15 in some detail. I'll just summarize the major hurdles I think that will have to be overcome in fitting cohabitees into Section 15 arguments. If you look at the definition, if you look at Section 15, which is set out on page 19, you'll see that different categories, race, national or ethnic origin, color and religion, so forth, you'll notice that marital status is not included as one of the enumerated grounds within Section 15. And the question is whether it's an analogous ground of discrimination, and that's what I discuss in the paper. It is included within human rights legislation across Canada, and there are various decisions which would read in marital status as an analogous ground within Section 15.1. The other question I discuss is whether it's necessary to show that cohabitees are a historically disadvantaged group. If we don't have to do that, then there's not much of a problem. If we do have to show that they are, I still think we can do so. There's plenty of evidence that they have been historically disadvantaged. We all know the status of children from the relationship, some of the cases making comments about them, the way that there's differential treatment. The only problem now is whether the disadvantage has ceased to exist. Has the position of cohabitees been so ameliorated over the last while, my goodness, that they're no longer disadvantaged? The other problem is whether or not being a cohabitee is a condition that's immutable. Is that something that's required within Section 15? But we should note that religion is one of the grounds under Section 15, and that's certainly not immutable. I also referred, I'll tell you briefly, there's a decision that's just gone up to the Supreme Court, and it was actually, they started to hear it last month, and I mentioned that on page 32 of the paper. It's the case of Myron and Dell. The issue there is actually not a family law problem at all. It's on uninsured motorist coverage, but the word spouse appears in the statute and is not defined in a particular section. And at trial, Madam Justice Arbor, she then was, held that the word spouse should be interpreted to include common law spouses, otherwise Section 15 of the Charter would be infringed. On appeal to the Ontario Court of Appeal, it was held that cohabitees are not a disadvantaged group. The net position is not one of disadvantage. That case has now gone to the Supreme Court of Canada. They started to hear it last month. The court was unhappy because the government was prepared to concede the Section 1 argument. And the court said they wanted to hear argument on the effect of Section 1 of the Charter, and something very interesting happened. They appointed an amicus curiae to submit a brief on Section 1, thereby forcing the government to justify Section 1. I thought that was a rather strange thing that had happened. So, of course, the case is now interrupted, and we're waiting to see what happens while the amicus curiae brief is filed. Since I am short of time, I won't. In the paper, I discuss the problems with Section 1, which they might be interested in reading about my views on Section 1, given they want a brief on it. And I do actually deal with that quite extensively in the paper. Given the shortness of time, I just want to pass on for the moment and say the Charter challenge is one way to go, and we'll have to wait and see what happens in Myron and Dell. The other possibility is through legislation, which is obviously my preferred solution. And as I say, I end the paper by saying I hope legislative reform will come about, and here we are, we have Ontario Law Reform Commission proposals to that effect. The full report I haven't seen yet, but from the summary, it appears as though the proposal is to extend Part 1 and Part 2 of the Family Law Act to cover cohabitees. There would be appropriate changes in the Family Law Act, changes in the preamble, and changes in the term matrimonial home, which would then become a family home. Some of the questions that I think will have to be dealt with are, do we want to change the definition of cohabitation, which is at presently in Section 1 talks about living in a conjugal relationship? And I know Professor Ryder, or if he has time, may address that particular point. The second is the time period of cohabitation. If cohabitees are going to be included within the Family Law Act, should we keep the existing definition, which speaks of 3 years cohabitation? Is that an appropriate period of time? The alternative definition is relationship of some permanence, and this will be changed to include this relationship of some permanence if they are the parents of a child. No reference, as there is now, to their being adoptive or natural parents. So that's obviously an extension of the extended definition. One of the main problems, I guess, is going to be retroactivity. Whether if we actually do bring in changes to the Family Law Act to cover cohabitees, how far it's going to be retroactive. And I gather the intention is to make it so. Perhaps that's not as horrible as it first appeared to me. When I think of the position of married spouses in the 60s and the enormous changes that have taken place in their position in the 70s and the 80s, they too have also been subject to a lot of changes in their situation. And I'm sure when they married, first of all, they probably didn't contemplate that all these things were going to occur. The other alternative, it seems to me, is a domestic partnership. Domestic partnership is probably most applicable for same-sex couples, but it's open to any couple. I think some heterosexual couples may want to avail themselves of the possibility of entering into a domestic partnership, which can be registered. The advantage of doing that is to make the Act apply to them right away rather than waiting for the requisite period of time. Another question I have is basically, and I don't have the details of what a domestic partnership will involve, and I think when we see the report, we may have more idea about that. What I wanted to ask, a question I have, I suppose, is what if the cohabitees are outside the definition of cohabitation, less than 3 years and they're not a parent, and they don't have a registered partnership, will trust doctrines, unjust enrichment continue to apply? Because my sense is generally there's an idea that we shouldn't be using these remedies very much in the family law context. The whole idea is to cut back on them, certainly in the case of married spouses. What about cohabitees as well? Will there still be some room for the operation of trust doctrines in the interim? Anyway, my conclusion is I'm very happy indeed that these proposals have come forward. I've been wanting this for some time, and I'm very pleased the Ontario Law Reform Commission has made those recommendations.
Thank you very much, Winifred. We'll now hear from Bruce Ryder on the subject of same-sex couples. Professor Ryder.
Thank you. It's hard not to experience a certain sense of deja vu listening to the opening comments that Professor Holland made, because I think it's quite it'd be an accurate observation to say that the situation of same-sex couples now is pretty much the same as the situation of unmarried heterosexual couples about 30 years ago. Namely, as Professor Holland described, that they're largely invisible within much of the legal system, although certainly in recent years the development of anti-discrimination law has provided a prominent forum in which to challenge that invisibility, particularly the recognition, of course, of sexual orientation as an analogous ground of discrimination under the Charter of Rights, as well as the inclusion of sexual orientation as a prohibited ground of discrimination in both the federal Canadian Human Rights Act and in the human rights legislation of, I think it's now 7 provinces, as well as the Yukon. But the invisibility, generally speaking, of same-sex couples, both social and legal, of course, gives rise to a great deal of ignorance regarding the attributes of gay and lesbian relationships, and the resulting misunderstandings occasionally surface in pejorative or ill-informed comments in the case law, much like the kinds of comments that we used to hear frequently with unmarried heterosexual couples, although less so now. I think a good example is a recent Manitoba decision in a case called Vogel, where a Manitoba judge, in upholding a human rights tribunal's dismissal of a claim by a gay government employee for same-sex spousal benefits, stated that the complainant was seeking to use human rights legislation to create a third gender with special legislative protection, whatever that means. The issue that I want to focus on today, one that I believe is likely to give rise to profound changes in the coming years, though of course it's always difficult to predict, but it's the issue of just the simple fact that family law legislation in this province and elsewhere in the country, and Canadian legislation generally, does not deal with the rights and obligations of gay and lesbian partners inter se. I'm just going to follow the same organization I did in my paper and briefly describe the status quo, which is fairly straightforward, so I'll try not to spend much time on that, and then turn to a discussion of what's happening in the anti-discrimination case law, both under the Charter and under human rights legislation, and then turn to what I think is the most relevant issues for the purposes of our discussion today, which is what the reform options are in the future for recognizing gay and lesbian couples within family law or within spousal status. Anyway, the simple situation at the moment is that gay men, lesbians, and bisexuals simply are not recognized in legislation as the spouses of their same-sex partners. They may be, of course, spouses from former opposite-sex relationships. They may be, of course, grandparents, parents, children, or siblings with rights and obligations under legislation like the Family Law Act, but they do not have rights as the spouses of their same-sex partners. So the Family Law Act, for example, has literally nothing to say about the rights and obligations that attach to lesbian and gay partners inter se. And the definitions of spouse, of course, in Section 1 and Section 29 of the Act are limited to married spouses or either of a man and a woman who have lived together outside of marriage. So gay and lesbian couples are not spouses and cannot become spouses even if they want to because of the common law definition of marriage as the union of a man and a woman. This means, of course, that there's no statutory right to the division of property, no rights and responsibilities in relation to the matrimonial or family home, no spousal support obligations, no right to claim damages upon the negligently caused injury or death of one's same-sex partner. Nor, of course, does the statute recognize domestic contracts between same-sex partners. Separation agreements or parenting agreements are also unrecognized because Part 4 of the Family Law Act defines those contracts as contracts entered into by a man and a woman. So in this legislative vacuum, and the Ontario legislation, of course, is no different than other family law legislation across the province or the country in this regard, and no different than other legislation, non-family legislation. But anyway, in the legislative vacuum, gay and lesbian couples, of course, have really no choice but to turn to the device of contract in an attempt to establish the legal consequences of their relationships. And indeed, it's especially important that they do enter into contracts, be they cohabitation contracts, separation agreements, parenting agreements, in an attempt to establish the legal consequences. The validity and effect of such contracts will be determined solely by the general common law of contract, unaided by the various provisions of the Family Law Act that help define the scope and validity of domestic contracts entered into by heterosexual couples. Whether and to what extent domestic contracts entered into by gay and lesbian couples will be held enforceable in the courts is anyone's guess at the moment. The one reported Canadian case on point, the only one I know of anyway, the decision of the BC Supreme Court in Anderson versus Luoma, suggests that a contract where it exists will indeed be enforceable, because the judge in that case did not find an implied contract between the two lesbian partners, but he was at least willing to look for one, but found that its existence was just not supported by the evidence. I suspect that courts in other jurisdictions will similarly abandon the older common law position that contracts contemplating a sexual relationship outside of marriage are unenforceable, just as they've abandoned that rule in the context of cohabiting contracts between unmarried heterosexual couples. So I think we can fairly confidently predict that courts will recognize the domestic contracts of gay and lesbian couples, but the extent to which these contracts can deal with certain matters, such as the parental rights and obligations of the same-sex partners and or sperm donors, is very unpredictable. On relationship breakdown, again, in the absence of statutory remedies in relation to property division or rights in relation to the family home, gay and lesbian couples really are limited to the equitable remedies of resulting trust, constructive trust, and quantum merit, which can play a very important role in the same way that it has, again, for unmarried heterosexual couples. The case law that the Supreme Court has developed in the context of unmarried heterosexual couples is, I would think, almost certainly equally applicable to gay and lesbian couples, simply because those remedies are extremely flexible. They can cope with the realities of a diversity of relationships. The application of the equitable remedies, of course, is not restricted by marital status or sexual orientation in the way the statute is. And there are at least three cases, the Anderson versus Luoma case is one, in which the constructive trust remedy has been employed in disputes between gay or lesbian couples on the breakdown of the relationships. So that's, in brief outline, the status quo. There's absolutely no recognition of gay and lesbian partners within legislative definitions of spouse. In the absence of legislative recognition, gay and lesbian couples have to turn to contract and equitable remedies. It doesn't seem to me that it's likely that the status quo is likely to be with us for much longer. There are a number of factors that are cumulatively creating very strong pressures for reform, most of which will be very familiar, but let me just quickly go through some of them. One, and the most obvious one, and one that has received a great deal of press attention in recent years, is, of course, the persistent pressure that's been created by gay and lesbian litigants determined to achieve legal recognition of the relationships so as to obtain the financial benefits, powers, rights, and obligations conferred on heterosexual couples by laws and practices. And of course, they're also seeking the legitimacy and validation that comes with that recognition. This is, of course, a relatively new phenomenon, one that's the product ultimately of the gay liberation struggle that began in the late 60s and produced enough social changes that it's now possible, though not easy, to be out and proud as a gay man or a lesbian. Another source of pressure for legal change is perhaps less apparent, but I think equally important, is the gender neutrality of many of the modern laws dealing with heterosexual spousal rights. I think if wives still had very different rights, for example, rights and obligations compared to husbands, as used to be the case, it would be far easier to argue that family laws respond to the distinct gendered dynamics of heterosexual relationships and therefore properly exclude gay and lesbian relationships. But now that family laws are gender neutral in the sense that husbands have formally the same set of spousal rights and obligations as wives do, the heterosexist nature of the exclusion of all gay and lesbian couples from spousal status becomes, I think, all the more transparent. Just to give an example of what I'm talking about, for example, in the Leshner case, although it didn't deal with family law, it dealt with the exclusion of a same-sex partner from inclusion in employment pension benefits. But one of the things the Ontario government argued in the Leshner case was that one of the purposes of providing pension benefits to heterosexual couples was to benefit or to meet the needs of women in heterosexual relationships. Which would have made sense, I suppose, if pension benefits were only available to women. But given that they were available to a spouse, either male or female, of a government opposite-sex employee, it was a weak argument, and the tribunal didn't buy it, noting that pension benefits were available to male or female spouses of government employees on the exact same terms, so long as their partners, of course, were of the opposite sex. So the benefits were thus an employment entitlement conferred on the basis of the status of being in a heterosexual relationship, regardless of the gender of the employee. And so I think that's an example of where the gender neutrality of the benefit is really fatal, or at least nearly fatal, to the argument that same-sex spouses should be excluded, or that the exclusion is justified. And I think the same kind of argument could be made in the context of the Family Law Act. Another source of pressure for change comes, of course, from the inclusion of unmarried heterosexual couples in many legislative definitions of spouse, including that in Section 29 of the Family Law Act. The legislature is starting to recognize that the reality of a relationship is more important than its form or marital status, and that the form or marital status of a relationship does not necessarily determine its reality. I think Justice Hugerson of the Federal Court of Appeal put this point very elegantly in the Schaap case, which dealt with marital status discrimination, when he said that it is a commonplace that the existence of the marriage bond is no guarantee of the permanency and stability of a relationship, just as its absence is no sure indicator of a mere passing fancy, as he put it. And the same argument can be made, of course, with respect to the gender or sexual orientation of the partners to a relationship. Lastly, and again a very obvious source of pressure for change, is the logic of anti-discrimination law that has as its central purpose the elimination of group-based disadvantage. Not just, of course, the logic of that law, but also the fact that it is supreme law, or a law that takes primacy over other legislative provisions in this country. So anti-discrimination law creates a powerful logic against the wholesale legislative neglect and exclusion of the interests of gay and lesbian couples. And the primacy of that body of law creates a momentum for legal reform that cannot likely be ducked for too much longer, even by recalcitrant legislative bodies. At the same time, you'd have to be living with one's head in the sand, I suppose, to not acknowledge that there are very strong pressures against legal reform that include, and I could go on about this for some length, I suppose, and this is definitely a partial list, but I think one important source of stubbornness on the part of the legislatures is the fact that most elected politicians simply are very, very hesitant to openly recognize gay and lesbian rights or affirm the equal value of lesbian and gay lives, fearing, I suppose, consequences in elections, even if they are supportive of those rights. Also, of course, is the perseverance, as Professor Holland alluded to, of strong moral perspectives that insist that marriage have a privileged, indeed sacred status, that ought to be reflected and bolstered by the law. People who hold that perspective often also believe that gay and lesbian relationships are sinful and immoral, if not perverse, and consequently are ambivalent, if not downright hostile, to the recognition of same-sex spousal rights. The widespread existence of such views means that, of course, legislative reforms in this area are only going to emerge after very heated struggle, and the judges are reluctant, understandably, I think, to initiate reform on controversial matters of public policy, even when the logic of anti-discrimination law creates a compelling case for such reform. Nevertheless, I think in recent years there have been, of course, very significant political and legal victories. The Ontario government extended same-sex spousal benefits to its employees beginning in 1991. New Brunswick and British Columbia have since followed suit. The Leshner and Clinton cases before the Ontario Human Rights Commission led to Board of Inquiry decisions that now require all employers in the province to extend spousal benefits on the same terms to unmarried heterosexual and homosexual partners. Let me turn to discussing the body of case law under the Charter and human rights legislation thus far, which I'm not going to go into in great detail either, because I've discussed most of the cases at length in my paper. But most of the claims, of course, are brought on the basis of sexual orientation, although claims based on marital status and family status enter into the picture as well. Sexual orientation, of course, is now recognized under Section 15 of the Charter, as well as under the Ontario Human Rights Code. But when you look at the national picture of the body of case law where gay or lesbian couples have been seeking spousal or family status, I think at the moment it's fairly easy to reach the conclusion that the cases, there's no consensus, there's rather real confusion, and I would say the cases are roughly evenly balanced on those that believe that it is discriminatory to deny spousal or family status to same-sex couples, and those that uphold laws that do so and dismiss discrimination complaints. The Supreme Court of Canada, of course, is ultimately going to have to resolve the division in the lower court decisions and in the tribunal decisions, something that they had an opportunity to contribute towards with the Mossop case earlier this year, but the majority anyway chose to essentially duck the issue and wait for the next case, didn't really pass judgment at all on the fundamental issues of whether gay or lesbian couples are discriminated against if they're denied family or spousal status. The Supreme Court will have an opportunity to resolve the differences in this area when it hears the Egan case, which it recently granted leave to appeal that case from a decision of the Federal Court of Appeal that held that it was not discriminatory to deny an old age spousal pension to a gay couple, even though they'd lived together for 40 years, and a heterosexual couple in similar circumstances would have been entitled to the same pension even after living together for 1 year. So the Egan case will be heard in the coming years and provides a very good case, one in which I don't think the Supreme Court will be able to avoid this time an examination of the issue. Anyway, on the cases that have upheld complaints include Leshner and Clinton, the two Ontario decisions I referred to, as well as a couple of charter decisions in the Vasey case and the Nodal case that I describe in my paper. There are also very strong dissents by Justice Leroux-Dubé in the Mossop case, by Justice Linden in the Egan case at the Federal Court of Appeal, and Justice Greer in the Leyland case, which was a challenge to the denial of a marriage license to a gay couple, and is on its way to the Ontario Court of Appeal. On the other side of the coin, cases that have denied complaints of discrimination brought by gay and lesbian couples to their exclusion from spousal status, there's, of course, the Karen Andrews case from Ontario, the Vogel decision from Manitoba, the Egan case on its way to the Supreme Court, and the Leyland same-sex marriage case. The argument in favor of striking down under the Charter heterosexually exclusive definitions of spouse, I think, is fairly easily summarized. The argument is simply that the differentiation of treatment, that is the exclusion of gay and lesbian couples from definitions of spouse, interferes with one of the 4 equality rights in Section 15. It's discriminatory if it amounts to the imposition of a disadvantage on gay men and lesbians, which is especially easy to demonstrate when financial benefits are at issue. Then under Section 1, what has to be shown is that the exclusion of lesbian and gay couples, if the government is going to uphold heterosexually exclusive definitions of spouse, it's going to have to show that the exclusion of lesbian and gay couples is rationally related to a pressing and substantial government objective, and that it's the least restrictive means of accomplishing that objective. Now, how that analysis would work in the context of the Family Law Act would be fairly straightforward. The exclusion of gay and lesbian couples from the Act as a whole, I think, obviously creates a disadvantage. It stigmatizes all gay men and lesbians by deeming their relationships unworthy of recognition in a statute designed to encourage and strengthen the role of the family. Moreover, it denies them access to remedies designed to facilitate the orderly and equitable settlement of their affairs and the breakdown of relationships, leaves their domestic contracts on an uncertain legal footing, denies gay and lesbian partners a means of emotional and financial compensation on the negligently caused injury of their partners. So the fact that there's a disadvantage created seems obvious to me, and the Section 15 hurdle ought to be easily overcome. And under Section 1, the wholesale exclusion of gay and lesbian couples ought to fail on the least restrictive means test, because the purposes of the Family Law Act, it would seem to me, are equally relevant to any economically and emotionally interdependent adult domestic relationship. And the achievement of the purposes of the Act is actually hindered rather than advanced by the exclusion of gay and lesbian spouses. The logic of that type of an analysis seems to me to be straightforward. I have my own perspective on the issue, obviously, but I have little doubt that in the long run, Justice Linden's dissent in Egan or Justice Luray's dissent in Mossop will someday have the same status as Justice Laskin's dissent, for example, in Murdoch versus Murdoch. It seems to me that the momentum of the law is clearly headed in their direction, as well as just the logical force of the argument. The arguments that are made on the other side in the case law that denies that the exclusion of gay and lesbian couples from definitions of spouse is discriminatory is essentially that they're treated the same as all other non-spouses. That gay and lesbian couples, when they're excluded, are not disadvantaged relative to non-spouses, and that the line between spouses and non-spouses should essentially be left where it is. Implicit in that analysis, of course, is that the line is currently drawn in an intelligible place. And judges often suggest that including same-sex partners as spouses would make the dividing line between spouses and non-spouses incoherent and impossible to sustain. Siblings, what we often hear in the judgments is that siblings, roommates, and even passing fancies would be included. Against that position, I think it can be argued that the current line is in fact not intelligible in relation to the objectives of various pieces of legislation. The line is now drawn at heterosexual status of a relationship, essentially, when it is the attributes of relationships that ought to determine whether they are properly included in a law or policy rather than the sexual orientation of the partners. In the case of the Family Law Act, it seems to me it's the status of being in a lasting domestic partnership characterized by economic and emotional interdependence that ought to matter rather than the sexual orientation or marital status of the parties. Judges often also refer to the capacity for procreation as the reason why drawing the line at heterosexual relationships is a rational way of dividing spouses from non-spouses. But again, I think the logical flaws of that position are also obvious. In the case of the Family Law Act, for example, the law is concerned with regulating heterosexual relationships, whether or not there are children involved, and whether or not the parents are biologically related to the children. Turning to the reform options, where are we likely to go? If I'm right that eventually there will be a consensus developing that the existing definitions of spouse, the exclusion of gay and lesbian couples wholesale from family law, is discriminatory, what are the options for reform? And I'm going to have to skip over this quickly, unfortunately, because I only have about 5 minutes left. The options, I think, can be divided into three categories. One, of course, is reforming the definition of marriage. The other is the creation of a new status through which people could voluntarily take on spousal rights and obligations, such as the status of domestic partner that Professor Holland alluded to. And the third is simply changing legislative definitions of ascribed spouse or common law spouse, such as that in Section 29 of the Family Law Act, to eliminate the opposite sex requirement in those definitions. And I argue in my paper that I think a combination of all three reforms would be the best way to promote equality for lesbian and gay relationships. Changing marriage law is something that, as a matter of the division of powers, the constitutional division of powers, only the federal parliament can do. And I think it's fair to say that we're not likely to see such a reform from Parliament in the near future, even with the change in government. They haven't even been able to get around to adding sexual orientation to the Canadian Human Rights Act. It's not likely that there's going to be a groundswell of support to take the far more controversial step of altering the capacity to marry. The other way in which the definition of marriage could be changed is by judicial ruling, because it's a common law rule that marriage is limited to the union of one man and one woman. That could happen as well. The Ontario Court of Appeal will be hearing, as I mentioned, an appeal of the Leyland case shortly. It's obviously something that I would think the judges will be reluctant to take on as well. And I think it's worth noting that if gay and lesbian couples are going to be accommodated through marriage law, much more needs to be changed than simply the definition of the capacity to marry. An obvious example being the consummation rule, the rule that a marriage is voidable until it has been consummated by an act of heterosexual intercourse would mean, unless it is changed as well, would mean that gay and lesbian couple, the legal status of gay and lesbian marriage would be rather uncertain, to say the least. Similarly, changing the common law definition of marriage in itself wouldn't do anything to bring gay and lesbian couples within legislative definitions of spouse, such as that in the Family Law Act, because the definition is either of a man and a woman who are married to each other. So marriage would remain an empty shell until all those legislative definitions of spouse were amended to remove the opposite sex requirement. The second option would be to create a new legislative status like that of domestic partner, which is something that I guess my colleague Professor McCamus will speak about, because that is what the Ontario Law Reform Commission has recommended. Unlike reforming marriage law, it is something that a provincial legislature can do, at least in terms of creating a new status that is open to people who want to designate as spouses. The provincial legislature, of course, could only change the law to include domestic partners within definitions of spouse within provincial areas of jurisdiction, and it would take cooperative legislative reform, again, from Parliament to achieve equal recognition of domestic partners to married couples, to amend the definition of spouse in the Income Tax Act, the Immigration Act, and other legislation. The models that exist for domestic partnership laws are, first of all, the registered partnership legislation in Denmark, which was passed in 1989 and is open only to gay or lesbian couples who want the same rights as married people, apart from the right to adopt or the right to a church wedding. Since then, some 1,300 gay and lesbian couples in Denmark have registered, and at least the first 4 years, 1,300 registered and 17 divorced. It's another. In Denmark, of course, they didn't have to face the complications of divided jurisdiction. In Canada, if the Ontario legislature follows the Law Reform Commission's recommendation, they couldn't include domestic partners within the divorce law, even if they wanted to. And finally, and I think by far the most difficult issue, is opening up spousal status by ascription, or common law status, so that spousal status would be imposed on gay and lesbian couples whether or not they register as domestic partners. And I think there are many instances in where that's not difficult. For example, in the context of employment benefits, I mean, if people want to designate their partner for the purpose of employment benefits, they should be entitled to. But in the context of legislation like the Family Law Act that imposes rights and obligations in quite a elaborate regulatory framework on at least the breakdown of relationships. It seems to me that there are really difficult issues in imposing spousal status on people when they have not chosen it. So domestic partnership is much less controversial in my view for that reason, because people make a voluntary choice to take on spousal status. But should it be imposed on gay and lesbian partners who choose not to take on domestic partnership status? The difficult issues being, as Professor Holland discussed, the autonomy objection, and also just the difficulty of drawing lines between spouses and non-spouses. It's simply not an easy task to decide who falls within spousal status and who doesn't. And that's something that I think has to be thought about in this context. If I had more time, I would discuss the existing definition of cohabitation, living together for 3 years in a conjugal relationship, or in a relationship with some permanence if the parents are the natural or adopted parents of a child. There's just real problems with that language when it's applied to gay and lesbian couples, one of whom may not be the natural or adoptive parent of a child. And it's important that social parenting be put, I think, on an equal basis with biological or adoptive parenting. Similarly, the language of conjugal is defined by reference to living together as a husband and a wife, holding oneself out to the public as a couple, and so on. And there are various other elements that can apply very problematically to gay and lesbian couples. I mean, it may be difficult for gay and lesbian couples to hold themselves out as husband and wife to the public. I've probably gone a little bit over, so I should probably just stop there. Thanks.
Thank you very much, Bruce. And now we'll turn to some of the solutions to the problems that have been talked about in this program. And we're very honored indeed to have with us the chair of the Ontario Law Reform Commission, and we're pleased that they released their results just in time to be discussed at this meeting. So we're now going to hear from Professor John McCamus on family law reform in Ontario.
Thank you very much, Jim. I approach this task with a bit of dividends for one reason only, and that is that the material I propose to cover in the next short while is complex and somewhat contentious. My worry is that in touching upon these difficult matters so briefly, you will feel no need to have a look at the extensive analysis which accompanies the discussion of these problems in the reports themselves. So having indicated my worry, let me forge ahead and hope that at least I interest you in the possibility of obtaining our reports, which are either out or coming out soon, reading them and getting in touch with us or getting in touch with the ministry to express your views. Those of you who wish copies of them need only let us know, and we will gratefully send them off to you in the hope that you might communicate your views back to us or back to the ministry. Shortly after the Ontario Law Reform Commission was established in 1964, it undertook a major study of family law. The resulting report on family law was published from 1969 to 1974. It was released in 6 parts, dealing with torts, marriage, children, family and property law, family courts, and support obligations. It was a pioneering and comprehensive study of family law which reflected then and now great credit on the director of the project, Professor Ian Baxter, who, as many of you know, taught here for many years and moved to the University of Toronto in about 1970, I think. And it reflects credit on the founding members of the Commission who tackled this great project. The report played a vital role in setting the stage for family law reforms enacted by the province in 1986 and 1988. In the early months of this year, the current members of the Commission determined that it might be fruitful to engage in a second look at family law reform. We had a couple of thoughts in mind. One was that it seemed not inappropriate for a Law Reform Commission to take a look at a field in which it had made recommendations at an earlier stage, which had in fact been enacted into law, to have a look at those laws and see whether or not the objectives outlined by the Commission in the first place were indeed achieved or achieved without problems. We thought we might learn something about the law reform process, quite apart from learning something about family law. We also knew that even though not very much time, only a few decades had passed since the Law Reform Commission last looked at family law, the social context within which family law matters must be considered has continued to evolve and appears to have undergone significant change even in that period. As the Commission itself noted in its original report, the earlier reports were not meant to be the once-and-for-all answer to all problems of family law. The Commission well appreciated, as we do, that family law is a subject in a constant state of evolution and change. Well, shortly after we set out on this course and read the old reports with great interest, it became clear that there were a number of areas in which a further round of reform was not just a possibility, but we thought an urgent and pressing necessity. First, our examination of materials submitted by members of the profession and scholarly work as well suggested there were a number of unanticipated difficulties with Part 1 of the Family Law Act, the equalization scheme itself. Secondly, we became convinced at a fairly early stage in the exercise, for the sorts of reasons that Professor Holland and Professor Ryder have indicated, that the narrow focus of much of the Family Law Act on married couples was in need of reconsideration. A third area of importance was revealed not just by contact with members of the profession, but simply by looking at the law reports. The extent to which litigation arises concerning the valuation and division of pension assets is ample evidence of the need for attention to this area as well. And so we resolved to try to produce reports on these three subjects: family property law, the rights and responsibilities of cohabitants, and valuation and division of pensions in the short-term future. We were encouraged in this by the Attorney General, who indeed, I'm sorry to say, invited, in terms of what happened to my summer, who invited us to report on these areas as quickly as possible. And this we have done. Our report on family law, family property law, was released last week. Copies are available now for those who are interested, not here, but they're available from the Commission. Our report on the rights and responsibilities of cohabitants under the Family Law Act will be released next week and similarly will be available to you. And we hope that not many more weeks will go by before our pensions report will also be available. It's a more complicated thing to finally edit and get off to the printer, and it's taking a little more time. In this paper, I'm going to try and indicate in short compass the general nature of the recommendations made in each of these three reports. For openers, though, I'd like to spend a minute or two elucidating the point I made already, that the social context within which we have to think about family law issues continues to change. And secondly, I'd like to try to identify some common themes or perspectives that we think informed the Commission's work in each of these three areas. First of all, context. A review of recent census data confirms the existence of some of the trends that I suspect we all see as part of our experience of day-to-day life. The phenomenon of family life remains a pervasive feature of the Canadian social context. 83% of the population reported living in a family as either a spouse or a parent or a never-married child in 1991, although interestingly this figure is less than the 87% reported 10 years ago. If family remains a pervasive experience, however, we know that it is also true that the form of the family is to some extent changing. The phenomenon of marriage is on the decline, as we suspect it to be. Divorce, on the other hand, is on the increase. As we all know, the decline in the number of families headed by married couples has been offset to a considerable extent by the increases in the number of unmarried heterosexual couples. That number has doubled in the last decade. And, of course, by dramatic increases in the number of one-parent families, that number has doubled over the last 2 decades. The average length of marriage now appears to be approximately 12 years, with the median length being as low as 10. Accurate data on the length of all relationships of heterosexual couples and the frequency of separation is precluded, of course, by the fact that we have information only about married couples, no information at all about dissolution of the relationships of unmarried couples. Well, the highest rates of cohabitation appear to occur for both men and women in midlife, interestingly, thus suggesting that cohabitation will often follow the dissolution of a marriage with some frequency. Further, we simply, in terms of trying to get an accurate sense of the context, we simply have no reliable data concerning the relationships between gay and lesbian couples in terms of the frequency of their occurrence, the average length of the relationships, and the frequency with which they raise children. Indeed, we have no firm data on the percentage of gay and lesbian citizens in our community, though estimates range from 4% to 17%. Obviously, an undetermined number of same-sex couples are included among the 6% of Canadians who report that they are living with non-relatives. Other data. The participation rate of women in the wage-earning labor force continues to increase. So too does the employment rate of women in husband-wife families with children under the age of 16. This rate increased from 48.9% in 1981 to 64.6% in 1991. Nonetheless, of course, the gender gap in wages remains a very real phenomenon. Further, women continue to spend more time engaged in unpaid labor within the home than their male counterparts. It's reported by Statistics Canada that employed women with a partner and children under 5 spend approximately 4.9 hours per day on such activities compared with 2.4 hours for their male partners. I'm sure most people in the room would agree that although it's only 2.4 hours, it's quality time. Taking out the garbage, raking the leaves, watering the lawn. I presume, Professor Holland, notwithstanding Peters and Beverley, you would say that this wonderful service is not to be paid for, and perhaps it's just as well. Canadians have not lost their attachment to the notion of a family home. In 1992, 79% of two-parent households with children owned homes. Interestingly, 32% of lone parent households, many of them headed by women, of course, also own their own homes. Well, one can't draw firm conclusions from data of this kind, but it is suggestive of a number of social facts that may well be relevant to thinking about how to reform our family law system. Serial monogamy does indeed appear to be a very real phenomenon. The replacement of married family life to a significant degree by the phenomenon of cohabitation is obviously there. There's obviously an increasing financial contribution to the wealth of households by women, an increasing accumulation of wealth by women, both through wage earning and through the dissolution of marital relationships. Well, some of that, I think, is quite relevant to some of the recommendations we ultimately came to make. In terms of common themes running through the studies, the topics can be separated out for separate study, but they are indeed interrelated. If you're going to do something about unmarried heterosexual cohabiting couples, it may well suggest a problem in the area of the matrimonial home and so on and so forth. Nonetheless, the subjects are severable, but we think there are some common themes that run through each of the 3 studies. First of all, equality issues. One of the significant changes that has occurred in Canadian Ontario legal cultural life, of course, is the growth and development of equality jurisprudence. Bruce Ryder has talked about this already. The Human Rights Code was adopted about the same time as the Law Reform Commission itself was created. And there's been an enormous growth, not only in the work product associated with this phenomenon, but an enormous growth, I think it's fair to say, in our sensitivity, collectively as a profession and as a society more generally, to equality issues. Things are debated now as equality issues that must seem very strange to elderly ears. Equality issues obviously run through our consideration of the cohabitation issue, but equality issues abound in family law, more particularly the extent to which family law has been and must, in the Commission's view at least, respond to the economic consequences of gender-based assumptions concerning the role of spouses and the economic structure of the family, infuses the analysis of virtually every aspect of this subject. Well, in our report on cohabitation, thanks very much to Bruce Ryder, we were able to offer an extensive analysis of equality jurisprudence, and in the light of his remarks, I will say nothing more about it today, except to say that it was present to our mind as we worked our way through these topic areas. But throughout all 3 projects, we very much tried to be sensitive to the sorts of anti-discrimination norms that have been sharpened and given legal expression in recent decades. So equality issues loomed large for us. Fair and equitable distribution of property was another theme. It's an old theme. It's the theme of the first report of the Law Reform Commission. We had little difficulty concluding that the Law Reform Commission and the legislature had come to the right conclusion in basic general terms about the need to have a statutory scheme of this kind, and that the basic elements of the scheme are sound in principle. Essentially, we saw our task as one of trying to give more effective expression to the principles adopted some time ago. Another theme, reducing the incentives to litigate. We were very much concerned in each of the areas, particularly though in the area of Family Law Act Part 1 and the Division of Valuation of Pensions, concerned to worry about the impact on whatever might be proposed with respect to the incentives or otherwise for litigation. We hope that we have, in the recommendations at least, reduced some of the incentives that now exist. Finally, we were sensitive, I think, hope we were, throughout the three reports to issues of personal autonomy. Personal autonomy in two senses. As a society, we've become increasingly respectful of lifestyle choices of individuals who, for one reason or another, have chosen to live in non-traditional family settings, and the Commission shared that perspective. And secondly, subject to the other important values of certainty, lack of open-ended discretion, and so on, set out in the scheme, we tried to preserve as much as possible the ability of the parties to a dispute to choose the solution that seemed most satisfactory to them. Well, let me talk briefly about each of the three areas. The report on family property law deals with a great long list of highly technical points that I'm sure I understood when we went through them, and I'm sure I understood them again last night, but I'm sure also that it won't be helpful for me to try to go through them all. Again, it wasn't our concern that the basic approach in Part 1 was somehow flawed and we needed to rethink all of that. Indeed, our view was that it was very sound and sensible. And some of the contentious features of the scheme, such as the inflexible valuation date, the inability to get a variation without meeting a pretty high threshold of unconscionability and so on, we examined and persuaded ourselves that they were in fact sound in principle, that these were the bedrocks of the scheme that again reduced the incentive to litigate issues of this kind. We did make a lengthy series of recommendations which are designed to improve the efficiency and fairness of the equalization scheme. We remained of the view that we ought to try to restrict the scope for the exercise of judicial discretion. On the other hand, we concluded that the inflexibility of the valuation date, the litigation that's been produced concerning substantial fluctuations in the value of the asset post-valuation date and before trial, strongly suggested that it would be attractive to have a statutory device for accommodating that problem. And we did recommend that courts be permitted to make an adjustment where substantial fluctuation in the value of the asset has taken place. Now, I myself voted for a scheme which no one else liked, which was to have a statutory formula for deciding when a fluctuation in the value of the asset had indeed reached the substantial test. I thought something like 2 times the consumer price index or something that wouldn't be accommodated for by interest on the initial award, 2 times CPI or something like that. But we were persuaded by members of this group, some of whom are here today, that that wasn't really necessary. One could simply say substantial valuations can be taken into account, and that would be satisfactory. So that is indeed what the report recommends. The report also deals with the problem of avoidance of the statute. There are not terribly good remedies now for avoidance behavior. People are trying to evade their obligations under the Act, and we recommended that where property has been transferred by a spouse with such an intent, a clawback remedy would be available. A number of recommendations are made with respect to the statutory provisions that apply in the context of equalization upon the death of a spouse. We were very much aided in that work by the work of Professor Albert Osterhoff from the University of Western Ontario. And indeed, I should say, in all of the work on this topic, we were very much assisted by the work that had been done by the Canadian Bar Association Ontario branch, which had filed a superb brief with the ministry some time ago. And it was particularly helpful in the context of the recommendations concerning equalization upon death. Further, we made recommendations to ensure that increases during marriage of the value of assets acquired independently of the relationship should also be shared, applying to that growth, if you like, the general principle that wealth generated during the relationship should be brought within the equalization scheme. Well, rather than go on at length about all of that or any of that, it seemed to me it might be helpful to focus on the two aspects of this report on family property law that are likely to be somewhat contentious. First, our recommendation that the special treatment accorded the matrimonial home in the Act be terminated. And secondly, a recommendation that access to the remedial constructive trust ought no longer be available to spouses pursuing remedies under the Act. Those who are outside the Act, the point raised by Professor Holland, it was our view that they would continue to have access to those remedies, but those covered by the statute would be restricted to their statutory remedies. Well, with respect to the matrimonial home, as you all know even better than I, the unusual treatment accorded the matrimonial home is that it must always be included in the net family property of the owner, whether or not it was acquired prior to marriage, and its value at the time of marriage cannot be deducted. This arrangement obviously departs from the central philosophy of the statute that spouses should share only wealth generated or accumulated during the marriage. On the other hand, this particular recommendation did not go nearly as far as recommendations made by the Commission in its 1974 report. In 1974, the Commission recommended that the sharing of the matrimonial home ought to be achieved by legislating automatic spousal co-ownership of the home, subject to certain exceptions. Well, our reflection on all of this led us to believe that there are a number of problems generated by the current statutory scheme. The anomalous treatment of the matrimonial home can give rise to what appear to be unattractively inconsistent results in very similar circumstances. I'll list the examples that we outline in the report. The fact that you must occupy the home on the valuation date means that there are some strange turns of fate when people move shortly before that event. Secondly, results in individual cases will obviously depend on the type of premarital property owned by a particular individual. Thirdly, as excluded properties not traceable into the matrimonial home, it would obviously be unwise to use an inheritance to pay off a mortgage on a matrimonial home, so that again, quite similar factual situations get treated rather differently. Similar problems arise with respect to debts. If, as appears likely, mortgages on the home acquired before marriage will be ignored in calculating the premarital property deduction, you're thus in a better position if you have such a mortgage than if you purchase the residence for cash and incur unrelated debts of an equivalent amount. Well, when you add up the list, there are a number of problems of that kind, inconsistencies which depart from the general principle that we ought to try and decide like cases in like manner. Ending the special treatment of the matrimonial home would obviously get rid of those issues, because they get rid of those anomalies. On the other hand, of course, there is instinctively, and I'm sure factually there exists, a body of opinion that says the matrimonial home is a special asset. Its special nature ought to be somehow recognized and accommodated in the matrimonial property scheme. We thought again about the recommendation that the Commission had made in 1974, automatic co-ownership, and concluded that such a scheme has a number of, call them practical problems. Newfoundland is the only province that has enacted a scheme of this kind, and the experience there well illustrates the point that automatic co-ownership is a bit of a mixed blessing. You get the burdens of ownership as well as the advantages. In one case, in Newfoundland, a wife brought a matrimonial home into the marriage. The husband, through the statutory scheme, obviously, acquired co-ownership rights, and he subsequently set fire to the house. I'm sure he was a very bright fellow, if somewhat temperamental, but it's entirely possible that he didn't realize that he owned half of the house when he did this. The insurance company, however, was able to figure this out and was able to refuse payment on the resulting claim as the policy excluded losses resulting from an intentional act of a co-owner of the property. Well, it's a colorful example. It's possible to imagine other situations in which owning the home or owning half of the home would appear to be something of a mixed blessing. Further, one must ask whether the co-ownership interest in question is going to be registered or beneficial. It's unattractive to require registration. Many spouses will be unaware of their rights and fail to do so. Many may not think of doing it because of the wonderful harmonious relationship which they enjoy. Others may find it inconvenient or expensive. For a variety of these reasons, people may not register. On the other hand, if you say it doesn't have to be registered, it's obvious that the scheme would create serious complications for dealings in land. Well, when we get to cohabitation, excuse me, I will explain again that indeed we are recommending that unmarried heterosexual couples be included on an ascriptive basis within the statute, and that essentially opting-in arrangements are available to gay and lesbian couples. If you legislate automatic co-ownership in the context of that kind of scheme, again, a number of surprises are likely to occur. Well, we concluded in the end that the preferable choice was just to end the special treatment of the matrimonial home. The advantages outweighed the disadvantages, providing that there is a parallel reform that would enable parties to share in the accretion of value during marriage of an excluded asset. If the matrimonial home happens to be an excluded asset, it would be better to be able to share the increase in value than not, and that is very much part of the package that we're suggesting. This arrangement would be consistent with the general principle of the scheme that wealth accumulated during marriage should be shared, a world in which shorter marriages appear to be an increasing phenomenon, a world in which individuals are increasingly likely to experience a series of relationships which, under our proposed reforms at least, all of which would be covered by the Family Law Act, it seemed to us a world in which property is often and perhaps increasingly owned by women. Remember the 32% figure which I started with respect to single-parent families, is a world in which it becomes increasingly difficult, in our view, to justify the special treatment accorded to the matrimonial home in Part 1 of the Act. Part 2 of the Act, of course, is another matter, and we very much recommended that Part 2, the rights set out in Part 2, be continued. So that's the matrimonial home. I think that recommendation, amongst all the other recommendations in the report, is the one that's likely to generate the most controversy, but I hope we got it right. Secondly, limiting access to the common law remedies. I'll just briefly summarize what we attempted to do there. Having fixed up what we thought were the most obvious reasons for wanting to bring a constructive trust claim, principally, as Rawlik and Rawlik itself shows, dealing with the problem of post-valuation date fluctuation, and having dealt with a couple of other problems that might be solved by constructive trust litigation. For example, the clawback arrangement. If you didn't have some kind of anti-avoidance clawback arrangement, you might think the constructive trust would be a satisfactory, or at least something you'd want to try in the context of a transfer of property which is undertaken essentially to avoid obligations under the Act. Well, with our proposal on clawback, we thought that particular use of the constructive trust is not likely to be necessary any longer. So we went through all the possible reasons for wanting to bring constructive trust relief and satisfied ourselves, rightly or wrongly, that either they were accommodated under the reforms we had proposed, post-valuation date fluctuation being the best example of that, or alternatively, that the reasons for wanting to bring constructive trust remedies were not particularly attractive or consistent with the general nature of the statutory scheme. So, for example, one might want to bring a constructive trust claim in order to achieve ownership in property and therefore get priority over third-party creditors in the event of an insolvency. The Commission, in its earlier report, had considered this question of priority over creditors and concluded that it should not be the case, that what should be shared under the equalization scheme was the surplus wealth generated during marriage or accumulated during marriage, not at the expense of the creditors, but after the creditors have been paid off. Well, we were persuaded that the same considerations still applied and that constructive trust relief for that purpose was indeed not a good thing to encourage. Secondly, what about the psychological benefits of ownership? Under the Act, of course, you get money. The constructive trust might give you the actual house itself. How about that as a justification for persisting with constructive trust? Well, we concluded that it's very easy to exaggerate the possibility of getting the home through a constructive trust claim. You're normally, of course, only going to get a portion of the interest in the home. We noted as well that it's indeed possible in unusual cases to get a transfer under the Act. And in the end, persuaded ourselves that although there might be a tiny, there in theory could be a tiny fraction of cases where you couldn't get a variation under the Act, you couldn't get a transfer under the Act or whatever, 50% wasn't enough in your case, and therefore you wanted to try the constructive trust remedy. In the extreme cases, surely the Act would solve the problem. Indeed, maybe in all of the non-50% cases, the Act would solve the problem. In any event, we were persuaded that to the extent there remains some theoretical possibility that you could do better under the constructive trust than you could do under Part 1, that wasn't enough of a reason for persisting with a remedial scheme which is really a most unattractive one, we thought, to encourage the parties to use. Well, we tried to narrowly confine that recommendation to deal only with constructive trust, remedial constructive trusts, and we're worried that people might start using resulting trusts if they can't have the remedial constructive trust anymore, so we tried to cover that point as well and preclude the use of that remedy in circumstances where the parties had rights under the Act itself. Well, there's much more in that report. I'll say no more about it today, but again, encourage you to have a look at it. I'll deal very briefly, since we've had such thorough presentations this afternoon, with the second report, the one which will be available next week on the rights and responsibilities of cohabitants under the Family Law Act. In the paper which I prepared for today, I have a lengthy discussion of the sorts of issues that Bruce Ryder identified in his paper and also identified in the background paper that he and Brenda Cosman, another Osgood colleague, most helpfully prepared for the Commission as part of this exercise. Indeed, between Professor Holland's work on cohabitation and Professor Ryder's and Professor Cosman's work, we had a very rich resource to work with, thank heavens, because it was a difficult subject to deal with in a fairly short period of time. So I won't go over that material in any detail this afternoon, but simply say, for the sorts of reasons Professor Holland alluded to, most especially, and this in the context of unmarried cohabiting heterosexual couples, most especially for the reason that we think, on the basis of anecdotal evidence we concede, we think there's quite a lot of confusion out there in the world around us about what the rights of unmarried heterosexual cohabitants are. Many members of the profession said to us, people already think they have all the remedies available under the Family Law Act, and this is a terrible trap for the unwary, especially for women, of course, and it is not helpful to continue in this confusion. Well, that was one of several reasons why the Commission came to the conclusion that it would be attractive to bring unmarried heterosexual couples under the Act, and to be sure, as a result, place a burden on individuals who had decided not to marry for the reason that they wished to avoid obligations under the Family Law Act, put the burden on them to enter into an agreement to this effect. It's not going to be satisfactory to everyone, we understand, but balancing on the one hand the improvements that this would bring to people who are in a very vulnerable situation, probably, as against putting the burden on those who've made a conscious decision of this kind to take that additional step and write it up. We felt that giving preference to the first of those two interests was the better solution. When we turn to similar issues relating to same-sex couples, again, equality issues loomed large. The sorts of functional arguments that Bruce Ryder outlined this afternoon, these relationships are in many ways very similar when one looks at the permanency of some of the relationships, the interdependency, both emotional and economic, and so on and so forth. The Commission came fairly quickly and confidently to the view that domestic agreements ought to be lawful under the statute, and that the Act should be amended to permit cohabitation agreements entered into by same-sex couples. Indeed, I think there's an awfully good argument. I imagine Bruce might agree that we're already there at common law. If that point gets litigated, it might turn out to be the case that those agreements can be enforced. In any event, we thought it should be clearly the case that domestic agreements would be binding. We thought as well that leaving people to write up domestic agreements would not be satisfactory for everyone. There'd be many people who would not do it for a variety of reasons. There would be people who would do it but not think of every eventuality. It is hard to foresee what might be the case in 20 years, etc. And accordingly, we thought it would be attractive to have a simple device whereby people could subject themselves to the provisions of the Family Law Act. And that's the notion of registered domestic partnerships. It has been adopted in some other jurisdictions. Once we came to the view that it would be an attractive device to have in Ontario, principally to deal with issues relating to same-sex couples, it then occurred to us, of course, that there might well be many heterosexual couples who would like to take advantage of such an arrangement. There might be other pairings of people that might like to subject themselves to those rights and obligations, and we saw no reason in principle why we would exclude them. Also, taking a more inclusive view of who might register under the registered domestic partnership scheme avoids the necessity for setting up criteria for membership in the list that involve privacy invasive criteria and inquiries of various kinds. You don't have to establish a conjugal relationship, in our view, in order to register under the scheme. You simply fill in the form and you're covered by the Act. Now, it's obviously more complicated than that, but I'll leave it at that for the moment. Now, after all this self-serving talk about equality, it will not have escaped your attention that we have recommended essentially an opting-out scheme for unmarried heterosexual couples and an opting-in scheme for same-sex couples, and it is reasonable for you to ask, how can you, after all that earnest talk about equality, justify this difference in treatment? Well, the best answer we have is the explanation for the decision we came to at that time. The question of whether or not to ascribe status to same-sex couples is, as Bruce Ryder said, a very difficult one. It's a highly contentious issue within the broader community. It turns out to be a highly contentious issue, as I'm sure you know, within the gay and lesbian community as well. Some would argue that anti-discrimination norms virtually dictate this result. We can't be treated differently. It's contrary to the Charter, et cetera, et cetera. Others take an anti-assimilationist view and deny the relevance of the stereotypical heterosexual couple, deny the relevance of that model to gay and lesbian relationships, and suggest that it would be a horrible thing, in fact, to ascribe status to gay and lesbian couples under the Act. Well, this is not an easy issue to wrestle with. The Commission was concerned that we really don't seem to know, neither the Commission nor people more generally seem to know very much about the kinds of relationships that have been developing with gay and lesbian couples. The evidence, I mean, if one tried to choose between these schools of thought on the basis of, well, what are these relationships really like? What kinds of expectations do people have? What kinds of, what is the length of the relationship typically? and so on and so forth? Is the breakdown of the division of labor within the home rather like what happens in heterosexual settings and so on? The evidence currently available on questions like that is quite ambiguous, and in our view, it would be inappropriate to impose substantial economic rights and obligations on a group of citizens without adequate information about their experience and needs. Looking at the position of unmarried heterosexual couples, we felt that the justification for imposing the statutory scheme upon them rested in part on the fact that the Act appears to be designed to give effect to the sorts of reasonable expectations such couples have to compensate for the kinds of uncompensated contributions that are likely to occur in such settings. And further, it was our view that those types of expectations and those contributions arise in part because of gender-based assumptions concerning such questions as the division of labor within the home and the making of career decisions and other economic decisions. Those factors on the face of it don't necessarily apply to same-sex couples. They might, but in the Commission's view, we simply didn't know enough about all of that, and accordingly did not think it was sensible to recommend taking this step at this time. But I would underline the phrase "at this time." Again, family law is an area where change is likely to occur, and that change may well occur on some future occasion, in our view. It may happen very quickly, notwithstanding the fact that, of course, that we haven't recommended it. Well, finally, I have only a couple of minutes, which in a way is a mercy for you, but also for me, to talk about the division of pensions, but I can talk about it very briefly, I think. In fact, it's probably more helpful to talk about it very briefly. I'm sure after what you've heard and indeed in the light of what you've experienced as professionals in this field, that I don't have to belabor the point that the current state of law relating to the division of pensions is quite unsatisfactory. There are a number of recommendations we've made in our report which are designed to ameliorate the problem. I would encourage those of you who have experience in this field to write both to the Commission and to the Ministry and give us the benefit of your thinking as to what needs to be done. Our report is in draft form, and I can tell you what it is we've recommended thus far. First of all, with respect to the existing if and when orders and agreements, the advice we received was that there are many of these orders which are a hazard not only for the couples in question, not only for the person who has an entitlement in question, they are hazards as well for members of the profession who may have drafted them in the first place. We hope that we're being helpful in recommending that a statutory power be conferred on judges to vary existing orders and agreements so as to make them work. From the pension industry, we heard that a number of them are drafted in a way which appears not to manifest a very clear understanding of how the particular pension plan itself works. It is alleged sometimes they are inconsistent, sometimes they're incomplete, they're unworkable. Pension plan administrators say this is all very interesting, but we can't do it and therefore we won't, and so on and so forth. Again, a statutory power to vary, hopefully, will be of some assistance to the parties and need we hardly add to their counsel. Even if you fix up the if and when scheme, however, it's still not a very satisfactory scheme in our view. And we've recommended, when I say we have recommended, as the Attorney General asked us to report as quickly as possible, we provided draft reports to the Ministry as soon as they were done, even though it's taking us a few more weeks to get them into publishable and published form. What we have recommended is the establishment of a thoroughgoing division at source scheme, which would enable people to divide pensions at source either by creating a separate pension plan for the non-member spouse. That is to say, one would, according to the formula set out in what is hoped to be statutory form, the non-member spouse would have a certain level of entitlement to pension credits, rather than buy them off, or rather than transfer them out into another pension vehicle. They could be left in the pension plan as a separate plan for the non-member, who would, under our proposals, become a limited member of the pension plan with rights to information and various other rights to make elections and so on. So those who want to, either because they can't afford the equalization process or for some other reason want to ride with the pension plan through to retirement, that would become a possibility. Alternatively, and this would be at the choice of the non-member, people could simply transfer out a commuted value into another pension vehicle if that was a more attractive scheme for whatever reason. And more generally, there is some thinking around these days that this kind of arrangement is so attractive that it ought to be imposed on everyone. It will improve pension planning. It'll improve pensions as a source of retirement income if you just force everybody into this mold. We resisted that idea. There may be many situations and many reasons why, for some particular couple, it's not sensible to divide at source. Young couples, for example, is the obvious case. Why would you want to force them to divide their pensions when they're 30 years old? They may have roughly similar pensions. Why would we put the pension plans through all the trouble of creating 2 new limited memberships, et cetera, et cetera? Some people may want access to cash rather than a share in an ultimate pension plan. For all of those reasons, we thought we needed to maintain equalization of the pension asset as a possibility, and that is very much part of the recommendation. Well, if you continue to have equalization, what on earth do we do about valuation? There, we were delighted to discover that the Canadian Institute of Actuaries has in fact worked up a standard for valuation of pension assets. And we recommended simply that standard, which is now effective, binding on actuaries, that it may be made binding on valuations under the Family Law Act by regulation. That was the good news. The bad news was when we talked to the actuaries about this, they said, well, the CIA standards do deal with a number of the more difficult points, but there are a number of additional questions that are really legal questions. And those legal questions are such as the following: whether retirement or termination method of calculation would be used, what the commencement age should be considered to be, the extent to which benefits that were not invested on the date of separation should be recognized, the recognition of death benefits in their valuation, the recognition of non-contractual inflation practices, do you include those or not, the method of adjustment for value on the date of marriage, issues related to income tax liability, et cetera, et cetera. The migraine headaches started immediately. I said, well, they don't look like legal issues to me. They don't sound like legal issues to me. But we were assured they are legal issues, and we sat down and wrestled our way through them and made recommendations with respect to each of those points, saying this is the rule one ought to have, and all of that should go in the regulations. Well, I'll stop there. The point of the pension proposal then is to make valuation much easier under Part 1 of the Act and to provide some options with respect to pension division at source, and basically make if and whens no longer a desired or useful object. Where do we go from here? I talked to one of my colleagues who said, I told him where I was going and what I was going to do, and I said, what sort of things do you think I should talk about? He said, the only thing you need to talk about is when any of this will happen. And he knew, as I am about to tell you, that I haven't the faintest idea whether or when any of this will happen. If you think some of it should happen, we would be encouraged to hear that from you, and others might like to hear that from you as well. Thank you very much.
Yeah, thank you very much, John. I'd ask you people as one last duty to complete your evaluation forms, hand them in at the registration desk, please, on your way out. And I'd like to thank again Brenda Duncan, the Director of Legal Education, Paul Truster, Laurel Evans, and Kathy Castaldo, particularly the co-planners and the program lawyers for this particular event. They've been most helpful, and the reason why things went so smoothly was because of them. I'd also, again, like to acknowledge the great contribution of the Planning Committee and the really hours of time they put in to get the program organized. And certainly I'd like to thank you, and especially your perseverance for staying to the last of a very heavy program. Thank you very much.